should, everybody from the board is here, so I think we should just get started. We just have to wait for our, for Larry to get us live, and then we'll get going.
You should be good.
Okay, great. Thank you, everybody, for joining us on this mixed in-person and live session of the zoning board. We're going to start by, I hope, approving the minutes of last month's meeting, which was August 16th. They've been circulated and commented upon as necessary. So do I have a motion to approve? Sure. Okay. Rosie's making a motion to approve. Anybody want to second it?
Sure.
All right, and we'll vote. Ken?
I wasn't in attendance, but
Okay.
but I did read them, and they read well.
They look good to you, so
Good to
you'll
me.
say yes. What about you, Judd?
Yes.
Yes. Rosie? Yes. And Joe?
Yes.
Yes. Okay. All righty. So the minutes are approved. So we will start with the first matter before us, which is 62 Butterwood Lane West. Do we have somebody appearing on that?
Yes, we do.
Great. Super.
Let's see. Good evening. Can you guys hear me?
Good evening. Yes, we can hear you. Yeah.
Great. My name is Andrew Hunt. I'm the architect for 62 Butterwood, and I can bring up a site plan, just kind of walk you through the ask. If I can share my screen. Let's see. It says only the host can share in this meeting. Is that something I can be?
Okay.
I can talk you through it if you prefer, but
I'll get that. Hold on one second.
no problem. Thanks so much. Okay, so it says, give me 1 second. Okay. Let me know if you can see what we have here. Let's see, can everyone see my screen?
Yes,
Yeah.
we can.
Great, okay. So 62 Butterwood Lane, 2.5-story house there on about a 20,000 square foot acreage, that'd be nice, 20,000 square foot lot. And the ask here is we've been over time, let's see, the current owners inherited the house or bought the house in 2020. And they've been making some small improvements over time here, and one of which that they're looking to do is finish their basement. And we'd had a building inspector by at a point, and it was deemed kind of not in as a right condition, need another means of egress. So that's part of what we're trying to achieve here with the new stair from the outside directly down in as a second means. The totaling is about 100 square feet of additional coverage on the lot, and fully understanding that this lot is over covered. Over the time, there's been a pool requested down the line. There's some, I think that was in the early 80s, some decking that was removed, and some other areas of patio replaced. So it's been a long lineage of, I think, variances in some respects along the way. And we, in trying to better the value of the house and the home and improve it for the owners and their use, this is our ask today, just in terms of asking for a variance of an additional 105 square feet for this stair.
And how far over existing? How well? I mean, I'm sorry, not over existing. How far over allowable are you on coverage?
Let's see here. I can pull that up for you in terms of the coverage chart here. We are. Let me see, where does it go? Worksheet here. We are a decent amount over. I think there's the total proposed, we're about 2,000, currently 2,000 feet over the allowable at this point, which is admittedly a decent amount. So again, why we're sitting above you here.
So percentage wise, where does that put you?
Sure. Percentage wise, total preferred coverage, it's calculating out to about, high 60s of the lot in terms of coverage at the moment.
And how much is this proposed project?
Oh, 0.5%. So let me see if I can just kind of zoom in to really grasp the entirety of it. I apologize for some background noise of a 2-year-old who won't go to bed. So the dashed in area here with the hatch of the stair is really the extent of the ask. Otherwise, you could see, I don't know if I can annotate on this as well here, but that might not let me do this at that time. I mean, you can see the patio cover there. You can see the pool, the house itself, of course, flag walkways. A decent amount of the rear yard there with the chain link fence, and the rest is trees and grass, and a good deal of it up into the neighbors and all that. But the area over right in here that we're looking at would be the extent of the ask.
Steps for egress. Got it. Anybody on the board have any questions, comments?
Yeah, I'm just wondering, is there any kind of hardscape that you might be able to trade for that minor ask?
Let's see. We tried to put it in a few other locations, to be honest with you. I mean, there's I think up against the house there where the patio paver are, and you can see the 2 little light wells on the back portion of the house. We were trying to put a stair in around that too, but that was kind of a permeable rock garden / grass, still not full coverage, had drainage capability. Some of the flag walkways are looser. I mean, they could be thought of differently in terms of maybe a different filtration system or something that's a little bit more porous and provides to the groundwater there. Something we can consider, but
yeah.
Sorry.
I'm sympathetic to their request because it's just a small staircase, but given how much already, if there was any loose brick somewhere that you could pick up where it would be an even trade, then I'd be certainly happy to do it.
Sure, I follow. Yeah, I mean, that's certainly something that we could look into. I mean, we're trying to in the attempt here is trying to get the up into the planning board this coming month as well, just to continue the process here, not push us too far back. But if that's something that we can look into and even show you in parallel to your resolution, it's something we could certainly follow up with by all means.
Any other questions?
At 67% over, how does that compare to the rest of the neighborhood?
It's a fair question. I mean, I think in what we've looked around the surrounding neighborhoods, those with pools and a decent amount of the kind of the necessary or I won't say necessary, but convenience paving to lead to those areas find themselves in a similar condition. I don't have the directs, but as an example, the owners' parents live right next door and have a kind of a similar layout and sort. Their lot's a little bit bigger, but there's a good deal of coverage in and around the surrounding properties. It doesn't seem in the context of the neighborhood that this is by any means out of reach for an ask. But again, it's subjective. I agree. We're not a one-off. I'll say that.
Interesting. Any other questions from anybody? Is anybody in the audience here on this matter or no? Okay. Look, I hate to hold you up. I know what it's like getting through these things. If you're going to the planning board, though, I would really prefer it if you could come back to us next month and find 100 feet of coverage that you could give back. 110 would be even better if you want 105. I really understand it's a small ask. This property unbelievably, I don't know how it's gotten approved in the past, to be honest with you, and look, there may be very good reasons why it has, but
Sure.
it's so far over that it just, I would imagine you could find 110 feet
And
to give us.
I don't disagree with you. I imagine we could do that too. My asking me what we're going back to the planning board with is going to be our second round with them. The first one alerting us that we needed to come to you, which was helpful. So if there's any way in parallel to find that 105 for you, even between now and that meeting, just to keep pace with obviously what we're looking at here for freeze thaw and the rest. If it's possible, great. It would be appreciated. If not, I understand.
Yeah, I don't think we can do that. I think we can just ask you to come back. If you can find that, I don't think you're going to, I mean, I can only speak for myself, but it is a modest ask, but it's just so far over. I think if you can find something and come back to us in October, I don't think you'll be held up much more than that, but I would ask you to see what you can do on that.
I mean, can I
And
make a
so-
suggestion here, or
Yeah.
is it? Yeah.
Absolutely.
I mean, even the flag walkway here that you see noted to the left of the AC units there, which is coverage at the moment here. If that was taken out to be, a grass paver or something like that allows over 50 or so, that's I think 220 square feet there. That portion of flag walkway, if that was reduced by 50% even, we'd be in a position hopefully where we could have that conversation.
All right, well, look, if I made a motion that we approve this subject to you removing that walkway and reducing the coverage by putting in stone pavers that I would be willing to make that motion, see if it gets by the board or not, and then we could be done tonight. You think that's something your clients would be willing to stipulate to?
I do. I mean, not speaking for them as best as I can. I think it'd be something they'd very likely consider to be able to push this forward and have something, with two little kids under there to have a finished basement. I think they'd make that trade in a heartbeat.
Where are you referring to?
So
in
you can
particular?
see, but where the AC units are on the bottom sort of
Yeah,
left side,
yeah.
there's a walkway there.
Okay.
Okay,
So,
so
yeah,
I will
the-
make
the-
that. I will make a motion to approve these plans subject to the removal of that walkway.
Uh-huh.
And replacing with something that is not hardscape, something that's porous, something that is soluble, water can get through.
Yep.
And do I have a second?
Well, Sarah, could we
Yep.
be more specific and just say there's no net increase in coverage?
No net increase in coverage. Yep. I like that.
So we have to 100%. So we have to balance out the 105 and take it out of
Balance
that flag
out.
walkway. Yeah,
Yep.
that's completely understood.
Okay, then I will make that motion. You want to second
I'll
it?
second it. Yeah.
Great, and we'll start with you. Yes,
Yes. Yeah.
Rosie?
Yes.
Yes?
Yes.
Yes.
Okay, terrific. So you are done with us. So good luck with the
All
plan.
right. Thank you so much. All right. Well, I appreciate your time. Thanks so much.
Got it. I'll send you a letter by the end of the week.
Appreciate it. Take care.
Thank you. Okay, great. Excellent. Okay, so our next case is 33 Park Road. Do we have somebody on that?
Yes, we do.
Good evening.
Hello. How are you?
Hi. Good evening, members of the zoning board. My name's Sean Jansky. I'm a landscape architect here on behalf of the homeowners, Tom and Molly. The project scope is an in-ground swimming pool with some associated work like fencing, gates, a small patio, etc. We have already been before the planning board and the village's consulting team, and they've done their review. The planning board has approved our application to move on to be heard by your board. We're here because in the village, the zoning code limits the construction of a pool to be no nearer the street than the rear wall of the main building. Would you like me to share my screen?
Yes, please.
Okay. Let me know if you could see that.
Yep, we can see it.
Yep, we can see it.
So this is a beautiful property. It's 5 acres. It's pretty wooded. There's some real topography on the site. The house is not sort of sited and situated in a traditional manner. So that part of the village code that, you know, really wants the pool to be no closer than the rear plane of the house just can't work here because of the way the house is sited relative to the street frontage. There,
So which part of the house is considered the rear?
uh,
I see Park Road all the way over there.
it would be here on the hillside.
Okay.
So, you know, again, it's a very nice wooded lot. I don't know if any of the board members had a chance to get there. It's a beautiful wooded property. There is this one fabulous sort of obvious level open area with no trees that's just perfect for the pool. But because of the way the house is sited, we need relief from that sentence, that part of the code. The project is well screened with existing plantings, and we've submitted some proposed plantings to enhance that. We also have a letter of support from 35 Park Road, who is in support of the application. We're seeking permission for the pool because there is no reasonable code compliant location to put the pool. There's a lot of topography, there's a lot of trees. So again, this is kind of a great spot for the pool. It's a typical in-ground pool. We don't think it's going to have any adverse effect on the neighborhood. It's similar to other pools that are on properties adjacent to this one. Although the property's large at 5 acres, much of it, if not most of it, is treed and has a lot of topography. So I think all of that provides some unusual circumstances, which is why we would like to put the pool where we propose it. It is a self-created condition, as the homeowners would like to put a pool in that they can enjoy with their family. And we also believe there's going to be no negative impact to the environment, and our engineer has submitted plans that have been reviewed by the village's consulting engineer.
And the pool can't be in the back of the house because of the way the property is graded. Is that basically it? It slopes down too much? Is that the issue?
That's right. You can see the topo lines, 260, 258. It's very steep. And because of that part of the code that wants it no closer than the rear of the house, you know, that's a prohibitive location to build a pool.
And this is the only variance you need. You don't need variance for coverage or anything else.
No, we're well under. We actually meet all zoning setback requirements. The other component of this is it's a very wooded and deer. There's a lot of deer on the property. So the other element of this is on the plans, we've requested a deer fence to enclose sort of a portion of the property that includes the pool and the areas around the house. So that's the other aspect of this, as that deer fence would exceed the typical allowable height in the village.
So it's 2 variants.
Yeah, although I have a question about the notice.
Yeah, we
Because
are
the-
only noticed for one.
Although it's referenced in some of the other
Yeah.
materials.
So I guess my question is this just how it's appearing on our list, or was it properly noticed to the neighbors that it was I guess it's 2 variances, but it's not showing up on our paperwork here as 2 variances, but was it noticed to the neighbors as 2 variances?
I'm not sure. I know that the village's consultant noted that it would require the deer fence would require a variance, and that was noted in our response memos, addressing some of the questions that came up during the village and consultant review, but I'm not sure about the wording of the notice.
Well, I'm just looking at the letter from Ed Marin, which only seems to reference the pool. So maybe do you need the variance for the fence?
Yeah, I noticed it in the paperwork, but because it was only noticed.
My associate's also on the call, and she's telling me that it is on the notice, but I don't have that in front of me.
No.
Yeah, but that's not the notice, right?
That would be given to the neighbors.
Well, I didn't print out all of that.
Yeah.
Well, that's what I don't know what was given to the neighbors and
Yeah.
everything, but.
I mean, just because we need to, make sure that anybody who might want to be heard about this, if there was an issue with the fence, was given the opportunity.
Well, this looks like,
Let's see what we got
that
here.
looks like.
Well, this has both things.
Yeah, it is on the notice.
Yeah, we just have lots of pieces of paper that have different.
Okay. So it does
Yeah.
seem like, all right, so it seems like this is something we can deal with. Tell me about the deer fence.
It's an 8-foot, light gauge, typical wire mesh, the kind that's very transparent. And would kind of do this portion of the property, sort of the north third of the property. And there's a detail of it shown on the plans and on the screen.
And basically the idea is to try to keep the deer out of the pool.
Yes. and deer ticks out of the humans.
Okay. Are there any questions from any board members?
I didn't quite catch how high the fence was gonna
8
be.
feet.
8 feet?
8 feet.
I mean, I'm familiar with the property. It is a very unique
is,
setting,
yeah.
and there's certainly no disruption to neighbors. And I agree that that's probably the logical place to put a pool.
Yeah, I got the chance to get up there and take a look as well, and it is a very unique property in that it's kind of tucked in there alone by itself. I can't see who this would impact, to be honest with you. Any other questions? Any questions from anybody in the audience or anybody watching from home with any raised hands there? I don't see any. Okay, then I will make a motion. I'm going to make a motion to approve. As I said, I don't see this really affecting any neighbors or anybody in any adverse way. It really is the logical place when you see the property to put that pool. I had a deer in my pool this summer, so I'm very sympathetic to the idea of the deer fence around the pool. Not fun. So I will make a motion to approve. Will anybody like to second it?
I'll second.
Okay, and Ken, we'll start with you.
Yes.
Yes.
Yes?
Yes.
Yes.
Okay, you are approved. I will send you a letter by the end of the week, and thank you very much.
Thank you very much.
Okay, great. Yes, went right through the pool cover too.
How'd you get it out?
It got itself out, but I need a new pool cover. Okay, Strawberry Hill Holdings is our last matter that is before us tonight. Do we have somebody here on that?
Yes, we do.
Okay, terrific. Hello? I think you are on mute. There we go. Yeah, we can't hear you.
It's showing mute, even though I know, I mean, I've had that.
It showed it
Yeah,
off
my own
and then
Zooms, yeah.
it's back on.
Try Alt A.
Alt A? Okay.
He's still on mute.
Now the signal came off.
Right, the little symbol came off.
No, can't hear him.
No, I could hear him a little. Turn up your volume. Maybe that would work.
Now the little mute thing is on again, the symbol. Yeah, did you go?
I try to log back in.
Yeah, that's probably the wise.
Yeah, the Zoom is weird, right? Sometimes it functions like video.
Right, that makes no sense. Yeah.
It's showing that it's not.
Okay, let's see if we can get it back. Crazy. Walking on. It was late spring. It's before I take the cover off.
No,
It's an
I'm
old cover. It's an old cover.
Yeah, because we have 6 foot fence, and I'm told they can jump
They
that.
do.
But
I don't
I've
usually,
not.
but they can.
yeah.
If he calls back, does someone need to let him in? You know, were you on top of that?
Yeah, I'm waiting to let him in.
Okay,
Yeah, Larry's there, so.
okay.
Can you tell what's going on, Larry?
No, all I can see are the attendees and he's not one of them yet.
The mixed protocol. No, do presenters need to be on Zoom, or they're welcome to join?
No.
They need to be on.
That's the way it is right now. I don't know how
Yeah.
long that's gonna last.
Okay, we got them back.
Oh, there we go. Let's see.
Thanks for your patience, everyone.
Okay.
Great. All right. Okay, well, it's good to have you and we can hear you. All righty, I guess we should start. Would you like to make a presentation? How would you like to start?
Well, do you mean the presentation itself, the one that I was going to deliver back in August, or do you mean the stuff that I briefed on the last week and then again today?
Yeah, I think on what we briefed for today. Yes, I think that's the preliminary hurdle we've got to get over.
Sure, of course. Yes. Yeah, so I think the submission today essentially does 2 things. And that first is it just clarifies that the precedent that I cited in my submission back on the 14th, the case of Morin actually was a matter that involved both a request for interpretive relief and a request for a variance. So I just wanted to clarify that based on the characterization that that matter received in the village attorney's statement on Friday. And then I go on and I basically tell the story of 22483E and 97B, and essentially why they look the way that they do. And so I basically start in February 1989, just as the site capacity law is passed as part of the overhaul under the umbrella of the LUC comprehensive plan. And I think by 1990, it's quite clear that there's a bit of a disconnect between the language of the village law, which specifies a village official, and the way that Irvington itself is using the planning board as although it is a body, as an administrative official for purposes of the site capacity determination. And so there's a kind of fiction that emerges that the planning board is the administrative official until they get pushed back on that idea, first in 1990 by Justice Carey of the Supreme Court, then again in 1991 by the same justice in Canyon Properties and the Eccles matter. And I think under the circumstances, it is, I think, quite plausible to believe that when the addition of the appeals clause in 22483 was made in December 1991, that it was these two recent Supreme Court decisions that were in the background. In other words, the village saw that it was making the planning board the administrative official for purposes of site capacity determinations. In other words, there had been sort of a crack revealed in the statute, and they patched it about 2.5 years later. I think the appeal of it, at least for me, is that I think it actually is consistent with some of the discrepancies that the village attorney has picked up on in her analysis, specifically the requirement that there needs to be an administrative official. But I think if you look back on it and with the perspective of the legislative context, you see that they were actually making these decisions back in 1991 with that very problem in mind. In other words, I think as far as they were concerned, they were solving that problem with the insertion of the appeals clause. I'm sorry, I know I said it was a story. I did not promise it was going to be an exciting story, but that's
not. Yeah. Mary Ann, do you have anything you want to add on this?
Yeah, I reviewed the papers we got this afternoon. It's at some length. And first I want to correct one thing. You're talking about between 1989 and 1991, how the board treated the planning board as an administrative official. I think the only case you've decided during that period, besides the two that were the subject of Judge Carey's decision, was the Pateman zoning board decision in 1989. But if you read that decision, it's Pateman 89-17 is the decision, and on page 7 of that, and this is the ZBA's decision. It says Misters Pateman and Caterino needed the requested interpretation because the building inspector had denied them building permits. So it was an interpretation based on the building inspectors. Now, I don't think that's so important though, because that's prior to the amendment. And I think what was submitted this afternoon further supports the position I made that the ZBA has jurisdiction to review a site capacity determination only if it's being asked to grant a variance. Now, the 1989 and 1991 decisions of Judge Carey, which Mr. McCulloch submitted at tab 2, were both rendered before the jurisdictional section of the zoning code was amended. Those cases held that the ZBA did not have the authority to review planning board decisions on site capacity, even applications for variances. I don't think Mr. McCall differed with that. At that time, the powers and duties section in the code didn't have the language that's there now about site capacity determinations. It read, now it might be, if you have my submission on the first page, it has what the current language is, might be helpful to compare them. So back then it only read, the Board of Appeal under the variances, the Board of Appeals shall have the power upon denial of a building permit to grant variances. So in response to those decisions, the zoning code was amended in December of 1991 to add to the ZBA's powers and duties the authority to grant variances from planning board site capacity determinations. So what that amendment did was add in the variance section, the Board of Appeals shall have the power upon denial of a building permit or determination of site capacity by the planning board to grant variances. It did not make any change in the interpretation section. The interpretation section still reads, you've got jurisdiction upon appeal from a decision by an administrative official. No change was made to that section. Now that amendment to 224.97, it used to be 243.97, but they're the same sections, was made in conjunction with the new section 224.83, which was 243.83. Any appeal from the determination of site capacity by the planning board must be made in the first instance to the ZBA. These two amendments were part of the same local law. The only reasonable way to read them is that the ZBA has jurisdiction to grant variances from site capacity determinations. It has no jurisdiction with respect to interpretations except those of the building inspector, which is exactly how 224.97 reads now. Now, the other case submitted by Mr. McCallick also supports that position. That was at tab 1. In the Khan case, Khan was seeking a variance. The planning board determined that his property had a site capacity of 0. Khan applied to the ZBA because he wanted a site capacity of 1. He was looking for a variance. In fact, on the last page of the Khan decision, the Court of Appeals states, here respondent is seeking an area variance. In the course of considering the variance, the ZBA necessarily had to interpret a provision of the zoning code related to whether the property was exempt from resource protection regulations because it was under separate ownership. The details aren't important, but there was a question it had to interpret. But the ZBA often has to interpret provisions in the zoning code in granting variances. That doesn't mean they're issuing an interpretation rather than a variance. For instance, let's say the planning board decides there's this site capacity of 3 for a particular lot because it subtracted 1,000 square feet for an unusual geological feature. Otherwise, the parcel would have a site capacity of 4. The property owner is convinced his, rock outcropping isn't an unusual geological feature and appeals to the ZBA for a variance of site capacity. To decide that, the ZBA would have to interpret what the code means by unusual geological features. But the application is before the ZBA because it's seeking a variance for 4 lots instead of 3. In this case, Mr. McCall has come to the ZBA not because he's appealing an interpretation of the building inspector or because he's seeking a variance planning board site capacity determination of 58 units. He's come to the zoning board because he wants you to reverse the planning board's determination. As I stated last week, and as I stated in my original submission, my first submission to you guys, the only way to appeal the planning board's determination was to bring an Article 78 proceeding to challenge it. And that's it, unless you've got any questions.
Do we have any questions?
I wouldn't mind asking a question.
Please do.
So, I mean, I'm a lawyer. I haven't had enough chance to kind of look super closely at today's submission. I previously thought when I saw the Moran case, that I didn't really care what position was taken 20 years ago, even if it was in maiden error. I was willing to take the advice of our village attorney. But I did, in reading today's submission, I did have a question, really, I guess, for Mary Ann, if you know the answer. What was in this 224-83 provision where it says any appeal from the determination of site capacity by the planning board must be made in the first instance to the zoning board of appeals? Do you know what that's referring to? What kind of appeal? Because you use the word appeal, are they inviting?
Well, meaning a variance, appeals are considered variances. Variances are considered appeals. Appeals
Okay.
from generally the building inspector. And the reason those both had, they were both passed at the same time because there was a question, hey, how do we appeal a site capacity determination so they don't have to, somebody gets a site capacity of 0 and they want to go to 1, or 3 and they want to go to 4, so that they don't always have to bring an Article 78 proceeding in order to get that resolved. And so then they gave them the authority, and it had to be special authority. There's a very unusual provision. You're not going to see it in other codes granting, giving the jurisdiction to the to zoning boards. It's an unusual, and which is fine, it's perfectly fair, but it's only for variances, not for interpretations. If you look at the 224-97 itself, the language A and B, B is very clear. You can get site capacity. You can get a variance from a site capacity determination. A is very clear. You can seek interpretations from a decision of administrative official. Essentially, the only relevant one would be the building inspector. Does that answer your point? Does that answer your question, Ken?
Yeah, it does. I'm with you on the second provision about the powers of the Board of Appeals. I guess in my mind, I always thought of appeals being, confirmed or reversed. I didn't really consider them being variances, but if in this context a variance is considered an appeal, that helps explain it to me.
Yeah.
Yes, you have a question?
Yes, Mitchell Adler, 91 Riverview Road. I'm a little confused by your interpretation. So I'm looking at the ordinance and it lists powers and duties, as you say, A and B. A, interestingly, first is interpretation, B is variances. In the description of interpretation, it says nothing about variances. Nowhere in here does it say interpretations have to involve variances. So I don't understand why Mr. McCalla can't bring his appeal based strictly on an interpretation. My other question is, as you point out, it says upon a decision by an administrative official, which you're suggesting must be the building inspector. If that's the case, why didn't they just say the building inspector? I mean, I don't see why looking at a board as tantamount to an administrative official is unacceptable. So those are my areas of confusion.
Okay, would you repeat the first one again? Because actually, I know. Okay, you asked why. Yeah, why
about
A doesn't
interpretation.
say why A doesn't say anything about variances? No, it doesn't. A is the power of an interpretation. B is the power of variances.
And Mr. McCallick is seeking
I know what he's seeking. The interpretation in A is an interpretation from a decision by an administrative official. And the planning board is not an administrative official.
Well, that's I think arguable.
No, it's not. It's
I
not.
think that's arguable.
It's
And
actually
the other,
law,
okay,
but-
the other comment I want to make is I somehow feel that Mr. McCallick is being denied due process. because he is bringing this appeal for interpretation. At the last meeting, or maybe the Board of Trustees meeting, you talked about how the zoning is being reworded to eliminate any confusion and to clarify it. If that's the case, that it needs to be clarified, then arguably it's subject to interpretation. So I don't see why the board seems to be doing a runaround without considering Mr. McCallick's appeal.
Excuse me, are you accusing us of running around?
No, I think it might have been the Board of Trustees meeting.
Ah, okay.
But at what, I think at that last meeting, the attorney for the village talked about how the zoning is being reworded to clarify it. If it needs clarification, then I think it's subject to interpretation. And I think that Mr. McCallick is due that interpretation,
And what about 224-74?
which says what?
Appeals. It says any person aggrieved by any decision of the planning board or any officer, department, board, or bureau of the village may apply to the Supreme Court for review thereof by a proceeding under Article 78.
Okay, it says may, it doesn't mean that's the only recourse.
That's true,
This says upon,
but you're arguing denial of due process. So you've elected not to pursue under Article 78, and then you're accusing us of denying due process?
well, why can't, you're claiming lack of jurisdiction, but I don't see where in the ordinance it shows that.
I'm responding to your argument about due process.
I think your denial of hearing his appeal is contrary, and doing it under the guise of not having jurisdiction is contrary to the powers and duties you have.
We haven't reached a ruling.
Right.
No ruling has been
Right,
made.
we haven't done anything yet.
But you're saying you're not even going to consider this because
No,
it's
we're
not your
not saying anything.
jurisdiction.
We're being advised by the village attorney.
Okay,
but we haven't made a
well, then I'm
determination.
addressing the
Right,
attorney
right,
and her opinion.
Right.
My apologies.
Your opinion, no. Are there any other questions for anybody from the board for either Mary Ann or the applicant or?
I would just make kind of a side note,
Yep.
which is I was surprised if indeed we were okay with granting jurisdiction for this as an interpretation, because within the papers, there certainly is an argument that there's a belief that the planning board misinterpreted terms. I would need to know how the planning board interpreted it. Like, I'm only hearing one side of this, of the merits of this. And so if the board wanted to somehow overlook this administrative official language, which I'm not saying it
Right.
should,
Shouldn't.
I think I wouldn't be prepared
Right.
to rule on the merits as we sit here today, because I really don't even know what the planning board's position is and whether there really is a misinterpretation or if they interpret it correctly and came to a different conclusion.
Yeah.
That's,
Right, that's sort of the next step,
The
but
next
yeah, I
thing,
hear what you're
yeah.
saying, absolutely. Anybody else?
Well, I'm with Ken on that, like,
Yeah,
you know,
yeah,
we need to get the planning board in here, we need to review their calculations if
Right.
we decide that that's an appropriate course of action.
right.
So we're not gonna decide tonight.
Right. But I do think we need to get over this first hump of whether or not
Absolutely.
we feel we have jurisdiction. Does anybody have any questions on that or comments or?
Can I just point out that there's an attendee with their hand up online?
Sure, absolutely. We will, just one
I
second.
didn't want you to go past that. Yeah, hold on one
No,
second.
thank you, Larry, I appreciate that.
Taylor Palmer?
Not quite yet. We're just gonna.
Okay, okay,
So- so I'm-
sorry, Taylor, hold on.
no, I was just gonna say that I'm sympathetic to the application because as kind of a lay reading of this, I'm not sure why an administrative official shouldn't be considered, an administrative body. But, I'm inclined to follow our legal advice because I haven't done the research myself, and I don't know if there are, significant reasons why this language was used. And so, I'm kind of stuck between a rock and a hard place, and I'm not inclined to go out on my own when I haven't really delved into the research.
So Larry, let's hear from the person who had their hand raised, if that's okay.
Good evening, members of the board. Can you hear me?
Yes.
Great. Good evening. Again, Taylor Palmer. I'm a partner with the law firm of Cuddy and Fader. We're appearing this evening, although you might be able to see me, on behalf of WBP Development LLC. They're the contract vendees for the 76 North Broadway property, which we sometimes refer to as the Maxon property. We are appearing tonight to address the jurisdictionally defective application that was submitted by Strawberry Hill Holdings, which wrongly seeks an interpretation of village code. To that end, I think the village attorney did an excellent job of addressing the facts that are before you in her earlier statement, but also in the written statement in support of the position of the zoning board, which does not have jurisdiction to consider the application. There's just 2 points that I think bear repeating as Strawberry Hill Holdings muddles the different sections of the village's code, I think, to effectively get them to say something entirely different, really, than what was legislatively intended or is clearly stated in their plain readings of those sections of the code. First, we'd respectfully submit that the Strawberry Hill Holdings submission effectively asks your board to act outside its jurisdiction, which is to ultimately consider their untimely submission that concerns the planning board's proper approval of WBP's planning board application for their site area, base site area related to their proposed development on the property. Importantly, that decision by the planning board is not a decision by an administrative official. It's respectfully submitted that Strawberry Hill Holdings submissions to the board are untimely, incomplete, and jurisdictionally defective, and they should be denied in those requests. To briefly elaborate, if I may, for the board, the zoning board is unable to review the planning board's pending determination or proceeding determination because it lacks the requisite legal authority to do so under the village's code and New York Village law. That does limit appeals to the Zoning Board of Appeals on a decision of an administrative official. New York's highest court, the Court of Appeals, has made it very clear that planning boards are without the power to interpret the zoning law, which is a power vested exclusively in the local code enforcement officer. Further, courts in New York have also addressed, such as the case here, that the Zoning Board of Appeals should correctly refuse to hear applications or requests, such as the instant request that appeals to the planning board's decision, because the forum for which to challenge that site capacity determination seeking an interpretation or to remove that determination would have actually been a special proceeding, as the board and the council have mentioned tonight, through an Article 78 or New York CPLR Article 78 proceeding. Strawberry Hill Holdings has failed to demonstrate why the planning board's site capacity determination is appealable to this board. And that's because this Zoning Board of Appeals is not the appropriate body to decide these questions. Secondly, if I may, in their correspondence that was dated today, 9/27, Strawberry Hill Holdings makes other misguided references to actions that are not remotely on point with the instant matter. Again, I think your council pointed out the distinguishing not on all four determinations from those prior matters, whether they're to be considered here, in an effort to further muddle the issues that are before you into a version of what I think Strawberry Hill Holdings would like for the zoning board to be empowered to do. However, facts are very stubborn things. In zoning code section 22497B and section 22483E, which were the board sections reviewed tonight and also in the attorney's papers, are crystal clear. The zoning board has jurisdiction to grant variances from a site capacity determination. Indeed, both sections of the zoning code were amended by the same law number 8 of 1992 in December of 1991, and only the powers and duties regarding variances was modified. So for the foregoing reasons, we respectfully submit that the board should deny Strawberry Hill Holdings' request in all respects. Thank you for the time to speak with all of you tonight.
Thank you. Is there anybody in the audience who wants to be heard on this issue of standing?
Oh, hi. Tony Altamira, 1 Meadowbrook Road. I'm an attorney too. I'm following a lot of this argument, and ultimately it seems like it all boils down to whether or not, from the jurisdictional point, the planning board constitutes an administrative official. Simply saying that it doesn't, without citing any specific case law, legislation, legislative history, whatever, doesn't really move me. I think that we probably need to have that explored a little bit more carefully before any determination is made on this point. Because in fact, if if it is an administrative official, then there is jurisdiction. The jurisdictional argument is satisfied. Personally, I think you should probably interpret this in a very expansive way to try to grant jurisdiction whenever possible, because I think it's beneficial for this body to make this determination rather than have to go to court and expend more resources and all of that. But in any event, I think just from what I'm hearing from members of the board, it sounds as if folks haven't really focused on that point, maybe don't know what the answer is. There's a whole lot of language thrown out by the developer's lawyer. But at the end of the day, I don't think he's referenced anything specific on the point. And if he did, there may be other positions that are to the contrary. So I think in the first instance, that ought to be explored before this board makes a determination regarding its jurisdiction. On the merits, on the substantive question, I think that the materials that have been submitted quite clearly demonstrate the argument as to why the interpretation by the planning board was mistaken. I mean, at least from the materials that I read, it's pretty clear what they're talking about in terms of the issue about driveways being roads and so forth, and the issue about the bonus, the bump that you get for all affordable units. And the fact of the matter is, this is a mixed project with some market and some affordable, and trying to argue that there's some kind of averaging concept that works to make that work, which is pulled from the low-income housing tax credit law as opposed to what we're talking about here, to me is beside the point. I think there's a jurisdictional question first. I don't think you're in the position to answer it, frankly, because I don't think we have definitive law on the issue, at least something that you guys could really sink your teeth into and analyze and make a thoughtful decision about it. And then on the substantive point, I think if you get to the jurisdictional point, if you overcome that, I think the substantive point is pretty clear here. I also think the fact that the Board of Trustees was entertaining an amendment to this very law to try to clarify these issues, to try to get over the hump, to make it work for the developer, essentially demonstrates that there's an issue with the substantive law. To me, it's quite obvious, a very significant issue. I think if that's the case, if that's the way this turns out, then the developer is going to have to seek a variance or an amendment to the law, which is one of the two options that I see here. But anyway, thank you.
Thank you.
Thanks, Tony.
Sarah?
Oh, Marianne.
Yes,
But
Marianne.
Yeah, I want to respond. Actually, I did cite authority for, in a memo I submitted, which the man who just spoke may not have seen. But there's a recent decision by the Second Department Appellate Division. It's a 2019 decision. And the court there upheld, the Supreme Court had annulled the ZBA's interpretation of its zoning law. And the Appellate Division upheld it because the determination was not made by an administrative official. And what the court says is, absent a determination of the building inspector or other administrative official charged with enforcement of the local zoning law, the zoning board was without jurisdiction to consider the plaintiff's application for an interpretation of the local zoning law. So in fact, I did cite authority for it.
But, sorry, may I speak here?
Yes.
As I pointed out in my memo, that authority doesn't really apply here, because that is the judge in that case was applying the default rule, which I think about which there's really no doubt that there needs to be an administrative official. But Irvington intentionally superseded that rule in 1991. So I would like to see the authority that says that that the planning board, once given the authority of being the administrative official, still can't issue an appeal that is then open to interpretation by the zoning board. That would be the kind of precedent that would actually be dispositive. That is, with all respect, that is really a sort of a side issue that the village attorney is bringing up. If I could also just keep going, that there was a a reference earlier, I think first by the village attorney herself, that the only reasonable interpretation of 83E is that appeals only means a variance. I think to most of our ears, that does not sound like a particularly reasonable interpretation. I think certainly a variance is a kind of appeal, but when we're talking about the Board of Appeals, I think the sort of entry-level knowledge about the work of the board is that it offers two varieties of appeals. It's essentially a foundational fact about the ZBA, that it offers interpretations in addition to variances. That is essentially the defining feature of the ZBA. So again, going back to 83E, it's hard to understand how the Board of Trustees would have written such broad, expansive language, any appeal, and have expected anyone to understand that they actually meant the exact opposite. That is essentially the village attorney's position. Any appeal, when talking about the zoning board of appeals, has to refer to both interpretations and variances. If they had wanted to say variances only, presumably they would have been able to say that.
Okay. Sarah, can I respond?
I also just, I'm sorry, if I could also just continue just to say that I think there's a similar argument to be made about the plain meaning of the word appeal here, right? That I think as the member of the board suggested, the word appeal certainly suggests to most people that in the ordinary sense that it is an attempt to reverse or at least modify a decision, right? Whereas a variance, of course, stipulates that the decision made by the administrative official was in fact accurate and they would like a variance from it. And finally, I would just, again, from a policy perspective, I've not been able to find a single other instance of the Board of Trustees limiting the ZBA's authority to variances only, with one possible exception when it comes to hardship waivers outside of 200, chapter 224. In other words, just playing the probabilities here, what are the chances that the Board of Trustees, in an effort to introduce a prerequisite administrative appeal, settled on doing something like that only for variances and left interpretations essentially a second track to go only to the planning board? It would be awkward to have such a bifurcated system, especially if it wasn't spelled out. And it would, of course, serve no obvious purpose. Again, I have not heard from anyone what the actual underlying purpose for that would be. And finally, if I could just add that there's a kind of a rhythm or a rhyme to the code, as I think, as we all know. And each of the sort of substantive statutes have a tail end that addresses the remedy question. The sort of, I think there was another board member who read out some language of that kind having to do with the planning board, presumably site plan review, if I'm not mistaken. In other words, you look to the end of the statute to see what your remedies are. If you do that, in this case, right, you are being told that the remedy is to go to the ZBA, any appeal. Okay, and sort of a related point that I believe that the village attorney is perhaps over-privileging the role of 97. Again, it has variously been called an enabling statute, or the sort of the description of all the board's powers and duties. Just a rough count indicates that there are at least 10 discrete powers that are not enunciated in 97. In other words, these are all powers that are assigned to the ZBA elsewhere in the code and not explicitly or even implicitly covered by 97. In fact, 97 warns us at the very start not to read it as an exhaustive list of its powers. So again, I hate to use this cliche, but I mean, this really is a case of the tail wagging the dog. 97 is essentially, I would imagine the sort of the afterthought when it came to elevating the planning board to an administrative official for purposes of site capacity determinations. The action is in 83E.
Marianne, did you have something? you
Yeah,
wanted to-
I just wanted to say that, I mean, 97 speaks for itself. When the board amended it in 1991, they only added site capacity determinations to the variance section, not to the interpretation section. They were very specific about it. And the statute speaks for itself.
I agree completely. And if you wouldn't mind, I would like to actually
While he's just looking for a section,
Yes.
can someone who has knowledge beyond me tell me what the Board of Trustees was considering or mentioned in terms of clarification? Someone mentioned that, and I don't know what
Yeah.
being referred.
Do you want me to? Yeah, they've got, they're considering several amendments to the, to the MFO, to the regulations for the multifamily office district. And one of them was to clarify whether driveways to multifamily buildings should be subtracted from base site area in determining site capacity. That's one of them. Another, and the two other changes related to whether, because the regulations require that if you have access off of Strawberry Lane or ingress or egress off Strawberry Lane, the developer has to improve so much of Strawberry Lane as to make, you know, that much of it safe, and that area would, that area would not be subtracted from site capacity. And then there's another one about height. And yes, I did say that was to clarify. There's no question. Nobody's saying that there was never a question here, but the time to raise that question was to challenge the planning board's decision, and it had to be challenged in an Article 78 proceeding, and it wasn't. For whatever reason, it wasn't, and you can't then create an interpretation opportunity for the zoning board to deal with it when you don't have the authority to give interpretations except from decisions of administrative officials.
If I could just follow up with a quick question to the directly to the village attorney, and it's a genuine question. Am I right in that this would really be the only instance in the entire code where the Board of Trustees elected to exclude interpretations and include variances as a form of relief?
I don't understand the question.
Again, I mean,
This is the only section of the code that deals with the zoning board's jurisdiction. So yes, it is.
okay, right, but I'm just saying the zoning board obviously has powers that are unrelated to site capacity determinations. So I just mean, if we look at the code,
Oh yeah, was this change about site capacity? Yeah, if that, it's really a quite unusual change, actually. If you went to I've been the attorney for maybe a dozen villages, and I've never seen a provision like this. But that's because I've never worked in a village that had site capacity determinations. It's a pretty unusual way of protecting resources the way the village does. And,
Okay.
and it was new in 1989, and they obviously from the litigation that there was in 1989 and 1991, they realized that there was a hole there. Wait a minute, how do we appeal these site capacity determinations? And then the way the Board of Trustees decided to fix that was to give the Board of Appeals the authority to grant variances. I'll tell you what's the unusual, and I'm not saying you don't have you don't have a right to raise all the issues you do. What's unusual, and this board has probably never seen, a site capacity challenge that wasn't seeking a variance. You've seen enough site capacity requests over the years, and they've all been for variances.
Right. I mean, I think we all know that interpretations are probably no more, I would guess, than 5% of all the matters that the ZBA sees. And I have actually, in my review, not seen a single case where the aggrieved party was somebody other than the homeowner, of course, but that that probably explains why there's so little precedent here. But I wouldn't.
Well, it would be the homeowner, because what happens, for instance, there was one, I think it was before any of you were on the board. I actually thought that the building inspector should ask for an interpretation, because it was whether you could use a garage, whether you could have a rec room in a garage. And so then they had to go, and he denied it, saying we need an interpretation about whether you can have, essentially residential space in a garage. And but there was a particular applicant, there's generally a particular applicant there, but the building inspector denied it and then asked for an interpretation.
Yes, my point wasn't that there's, my point was only that interpretations are rare, and
Yeah, they're unusual.
Interpretations filed
For
by.
whatever years I've been representing the board, I guess about 11 years, the village, the interpretations have all been of decisions by the building inspector, or interpretations by the building inspector.
Okay, since we are talking about precedent, I would appreciate it if you could just repeat exactly the basis for distinguishing the Moran matter. Again, this is not a matter
for the basis for distinguishing Moran, which she was speaking.
If I could just finish the question first. It's just that, again, because it actually applies to what was said about Kahn and Pateman as well, right? The fact that the applicant was also seeking a variance, to me, seems irrelevant to answering the question of whether the ZBA has jurisdiction over interpretations, right? As far as I know, and I have looked into it, there is no equivalent of supplemental or ancillary jurisdiction in the ZBA. You either have the jurisdiction to entertain that form of relief or you don't. Right? And so Kahn was asking specifically for interpretive relief in the form of reversal. The same thing with Pateman, the same thing with Moran, right? Before 1991 and after 91. Now, I still don't quite understand how you can claim that Moran, for example, was a variance case when in its second turn in front of the Supreme Court, the very question that was being raised was, should she have received the interpretation that she was actually requesting rather than the variance that the ZBA gave her instead? That was actually the question in that case. It's, again, this is not.
You know what, you make your questions so long, it's hard for me to answer them.
Okay, I'm not sure how you can distinguish Moran.
Okay, I distinguish Moran because in Moran, she was seeking a variance.
As well as interpretive relief.
No, you know what, applicants put whatever they want on their applications. They say, interpretation and or variance. And often sometimes, and the ZBA in the past has called things interpretation, but the issue didn't come up. The reason the issue came up this time is it was just a pure interpretation, not a variance. And in Moran, and as I said, it may very well be that in saying, I want a site capacity of 1 instead of 0, that the zoning board is going to have to interpret a provision of the law. There's like so many variances that they grant, that they have to interpret provisions of the law.
I mean,
And with Khan, it was the same thing. And in fact, if you look at the end of the Court of Appeals decision, the court actually says, this is an application for an area variance. Here responded to seeking an area variance. They were seeking variances. In the course of the variance, the ZBA had to give interpretations. It isn't just applying for an interpretation, which is what you did. There's no doubt that if the property owner here had said, listen, you made a mistake, you shouldn't have subtracted those steep slopes, and I think I have a site capacity of 60, not 58. So it comes to the zoning board, and they can consider, you know, they might have to interpret some language about steep slopes. That doesn't turn it into an interpretation. It's still a variance they're seeking.
but they're also seeking reversals of the planning board decision. That is,
Yes,
again,
which
I don't, that is coming from both.
you can get a reversal of the planning board decision if it's a variance. You're not seeking a variance.
I'm sorry, that.
Okay,
I think we're kind of going in circles at this point. I mean, I think everybody's made their points on both sides. So
I do have
before
one
I,
additional point, if I could just, I'm sorry, I do regret to do this. I'm certainly not looking to tax anyone's patience, but
no.
I did ask earlier about any precedent elsewhere in the village code for the Board of Trustees carving out interpretations for essentially a dual track system, creating essentially a dual track system where, in other words, the VBA could hear an issue on the variance side, but not on the interpretation side. And again, from the way I read the code, that does not actually happen anywhere else. In other words, what the village attorney is proposing here is an extraordinary departure from every norm that the Board of Trustees has ever established. I would also just like to add that I just recently, as in within the last couple of hours, came across an opinion letter from the state DOJ, essentially giving an opinion on a very related question. Sort of the bottom line of it being that a village is actually not authorized to divide the ZBA's appellate jurisdiction, favoring one form of relief over the other. In other words, that is something that would require very specific evidence of intent and the standard language accompanying.
I mean, I think what Marianne is saying, and Marianne, correct me if I'm misinterpreting what you're saying, but I think what you're saying is they did carve this out very specifically, which is kind of what shows intent to you, because they've never done anything, you know, to say that this is something that we can do by variance, but not interpretation, but it has to be, from an administrative official.
Yes.
Is that essentially, I'm garbling it a bit there, but you get my point. I mean, you're sort of saying this
I
wasn't.
agree with that.
If I could just to be completely clear, right, an administrative official from the perspective of the village attorney in 1991 would have included the planning board. Again, so it is completely consistent with the going interpretation of the village attorney. It is essentially the same argument that they were making in court in front of Judge Carey, ended up 7 months later going straight into the code.
And they lost. That was the argument they made, and they lost. And so
Right.
then the board fixed it.
To fix the code, exactly. So they essentially they made their theory law, which is the point that I was making in my brief today.
Now, the law is the law. The law is 22497.
I'm afraid that the law, there's more to the law than that, ma'am, and it's also 83E. Any appeal, again, I'm sorry, but in the ordinary sense of appeal, there is no carve out just for variances.
Well, Well,
Yeah. Go ahead.
I think in your submissions, one of which rather lengthy one we just received today, you make a compelling case for the fact that it was those decisions where the finding that the planning board was not an administrative official, those court decisions, that the amendments were in response to that, just the timing and everything else. But and I'm not quite sure, I don't know how to come down on this, but the fact of the way they made the amendments, if they had just added the provision to allow for any appeals of site capacity determination, I would think a broader interpretation would certainly be the most compelling. But at the same time, they added the amendment to add in the site capacity only to the variance provision of the powers of the zoning board. And to me, you have to assume that they meant something by that, by not adding that provision into the separate interpretation provision.
I agree, and I believe that is consistent with the argument I was making, that their theory was that the planning board was the administrative official for purposes of site capacity determination. They were floating that theory, as I think I indicated in one of my footnotes, as late as 2006. It never went away.
But if that was the point, I think it would have been a different type of amendment.
I agree that it could certainly have been clearer to say.
I think we could all agree on that.
Yes, yes, that obviously.
Again, I mean, but this is not a case where there's much ambiguity genuinely, I say that because any appeal at the end in the remedies clause of that section really signals only one thing, and that is both interpretations and variances. I mean, we are talking again about the Board of Appeals. There are only two kinds of appeals. If you wanted to select one and not the other, you could have easily done that rather than use the word that would have, especially in this context, applied to both.
Larry, somebody looks like they've left a message in the chat, and I don't want to ignore the people who are participating remotely. So is
Yeah,
that something that?
I have one person with their hand up. I don't have a chat message, but
Okay.
yeah, that was me to Taylor when I took him off of put him back on mute. But I do have one person who wants to make a comment. So you tell me which order you want to do it.
Okay, yeah, why don't you go ahead with that, and then we'll hear from you. Yeah.
Sorry to double dip again. It is Taylor, and I am now unmuted again. Thank you, Larry. Just one quick point. We do appreciate the comments presented by Strawberry Hill Holdings. We're here and we're hearing those comments, but Mr. Michalek is aware that they had the opportunity to bring a challenge within 30 days of an Article 78. That was the available option, and they didn't do so. They actually brought this interpretation request on the 60th day. I think it was a Saturday, and submitted about one page seeking this interpretation from your board. And then only a few weeks later did they submit additional details. But again, that didn't support that your board has jurisdiction. So I think rather than going through the front door, this is really a sort of it's confusing backdoor workaround but it doesn't get you to jurisdiction. It's just confusing the issues. The law is very clear, and the appeal to a zoning board is proper when seeking a variance, specifically when it's related to the base site capacity determination, but not an interpretation. And of course, the planning board is not an administrative official, but I think that was already well addressed through the case law presented. But we just wanted to note again that the issue before the board and what Strawberry Hill Holdings is aware of is the challenge should have been brought in an Article 78 within 30 days. They didn't timely do so, and then only on the 60th day brought this interpretation request, which again is not the right forum. Thank you again for letting us double dip, so to speak.
Thank you.
Oh, hi, Mitch Adler again. So if we step back from the legal arguments, which I don't think have definitively answered the underlying issue, what I'm hearing from a practical point of view, based on the village attorney's interpretation, is that if the planning board makes an error that disfavors the landowner, that landowner has recourse within the village. But if the planning board makes an error that favors the landowner, the village residents, the board of trustees, and this board have no recourse within the village. And that doesn't make sense to me.
Other than through Article 78.
Within the village, right, but why would we not want to be able to resolve that within the village? That says you may do that, but it doesn't say you must do that. And again, I don't understand why the village would relinquish the opportunity to resolve that issue. I don't think that was the intention.
Anybody else in the audience or joining us remotely have a comment? Anybody on the board?
I mean, I'm sympathetic to Mr. Adler's point, and I wish there was another workaround, but I'm not. But there may have been some reason why the language was what it was, and I think my hands are tied.
All right, so I guess I'm going to make a motion. It's a little awkward procedurally. I'm not sure exactly what the motion will be, but I'm going to make a motion. I think this is a pretty complicated matter. It's been extensively briefed by both sides, and everybody's made good arguments. I think it is a difficult case because there is very little case law. There's some, but it's not a lot. But to me, I just don't think at the end of the day that we have jurisdiction here. I don't think that the planning board is an administrative official. I just don't, by reading both the law and the cases associated with it. And this is not the first time that every one of us on this board has heard that Irvington has some funny zoning laws, and people tell us that all the time. But I think the law as it was intended is that we were not meant to hear this. So I'm going to make a motion that we not proceed with this. There, in my opinion, as everybody has said, there was a forum for this. It's just not here. Does anybody want to second that motion? Messy as it is.
I'll second it.
Okay, so Ken is going to second it, and we'll start with you, Ken. So I guess yes in favor of my motion, right?
Yes.
Okay. Or no?
Yes, in favor not to proceed.
Okay. I'm yes as well.
Yes from me also.
Am I allowed to abstain? I mean, I just find the legal issues
Yep.
overwhelming. I'm not an
Yep.
attorney.
Yep.
Right?
Absolutely.
And I didn't have a
Abstain.
chance to read
Yeah.
Peter's brief, which
Yep.
came at 4:30 this afternoon. So
Right.
I'm
Yep.
just gonna sit it out.
Well, I'm sorry, but could we not leave the hearing open just to have everyone have a chance to read the brief? I mean, I naturally I'm a little bit more fond of it, but I mean, I do think it actually tells the story in a way that will actually reconcile some of what we're hearing from the village attorney with my argument. Specifically, Chairperson Gardner, the reference that you just made to the planning board not being an administrative official, I mean, that's actually not what I don't think the village attorney is actually saying. The village attorney must concede at some level that the planning board is an administrative official, but only for purposes of the variance. Right? So in other words, the argument, as you said, it is very, very complicated. I would just suggest
No,
that we keep the
I
hearing-
appreciate that, but I have to say, I did read all of the papers. And I think 4 of us felt comfortable voting on what was before us based on our availability to read the materials and go through it. And by a vote of 4 and 1 abstaining, the motion to not proceed passes. Thank you very much. I appreciate that it's been a long road, and I'm sorry. I know a lot of people, I know you're going to be disappointed by that, but I think that that's the right decision. So thank you. And thank you, Marianne, for being available to us tonight. I
Yeah.
appreciate that.
Okay, thank you.
Okay,
Bye.
meeting's adjourned. Thank you.